Coming back after lunch. We are now going to have the first of our two big debates. This debate, under the chairmanship of Dr. Brad Beira, is on funding and care for cerebral palsy and others living with disabilities. The panel participating in the debate is sitting in front here, and Dr. Beira will run the debate.
Thank you, Herman, and thank you to the panelists who unwittingly agreed to be part of this. And hello again to all of you. The idea is a freestanding dialogue with some two-way engagement, because it's a dialogue only if there's two-way engagement. Otherwise, it's just a monologue, or it's a little bit didactic. What I've put up to just create for orientation, we're talking about funding and ongoing care for persons with cerebral palsy, but it's obviously much broader than that, because while it presents the majority, there are a large number of head injury persons and persons with various degrees of intellectual and mental disability and physical disability that would fall into that. Then, the question is, how do we define who the eligible persons are? How do we create and stimulate the centers of excellence, those that exist and those that are potentially new? How do we drive access to care, and how do we look at the enabling legislation as it stands and how it might change into the future to stimulate the debate? And this is for the panelists to really say how they like to go. But the question would be, how do we begin, and I'm using terms from this morning, with the process of diagnosis and the certificates of harm? Because for a person to fall into the eligibility, there has to be a gateway that they walk through. The second question then is, when we discuss awards, lump sums versus periodic payments versus top-up and clawback trusts versus state-funded provisions like the NHI scheme or a Guardian scheme, then that also opens the door for pecuniary and non-pecuniary awards and awards for damages, and Chris and I were speaking very briefly about that. That then bridges across into models of care and the models of care that we'd like to do. Alison has some very sobering slides that I think, Alison, if you're comfortable at that point, you'll come and you'll run those slides and take us through your experiences in terms of real on-the-ground case management. And then ultimately, what do we want to try and achieve in funding models of excellence? What are the existing models, and what could models work with going into the future? Does that sound like a reasonable way to spend the next 45 minutes while you eat candy and keep your blood sugar levels up? So looking at the panel and asking you, is there somebody who'd like to start this discussion and debate? Alex, possibly from your side in terms of the architecture of your experience and where you think it might go?
You must be clear.
I think one of the sort of key points that I would begin to make on this kind of discussion, firstly, is that we're currently treating what is a long-term ongoing issue as if it were something an aberration in the system, as if medical negligence is something that's just going to go away at some point. So once you realize that, in fact, the medical negligence is not going to go away, then you have to put a system in place to manage it in a coherent way, because otherwise you will have many different sort of arbitrary approaches. And then there is the distortion, the number of cases that we have relative to the number of cases that we should have, and addressing those. And again, that requires another set of systems. So I think that the question is, what's the system that needs to be in place to manage the clinical care of the cerebral palsy cases, for instance? But if we raise the issue that was also raised in the morning, which is why we're treating the people who are recipients of medical negligence payouts differently to those who get cerebral palsy without medical negligence. Should we be treating them differently? And potentially the answer is no, you shouldn't necessarily be treating them differently. But then when you're looking at an equitable framework for all of them, then you've got to have, have to create a system around cerebral palsy, which we don't have. So I think that raises a number of complex issues. I think that just creating a system to manage a liability isn't the way to do it. So I think that there are many different, very good system solutions that South Africa could implement around these things. The issue, though, is who's going to create it, who's going to set it up. So I've raised one important point, I think, initially, was who should actually take responsibility for designing the system. And one of the things that you'll find that's quite difficult when you kind of say which department should do it is that a health department, for instance, might propose it, but a national treasury might then become an adversary in the final framework. So here is a problem that needs to be solved as a joint action of government. It's potentially a national function. This does need to be resolved at a national level. And right now there isn't really an institutional space to take responsibility for this, but clearly health can initiate the establishment of this framework. But I think that everything that has been suggested in the morning can be put into a coherent framework. But I think that it's going to be the institutionalization of that is going to be the sort of the central question.
It's an interesting reflection when we began this debate, not only on Wednesday, we didn't begin the debate on Wednesday, it's been going on for a very long time, but on Wednesday when we started wondering what were the towers or the verticals or the streams that we may want to speak this into. Does this argument get orientated towards the Ministry of Health or Justice or Treasury or Social Services? Or does it sit within the Ministry of the Presidency? Where does it live and where should it belong? Because if there's a no-fault view that cerebral palsy is not the fault of the individual who has it, then we look not in a mechanism not dissimilar to the occupational health and safety system that says your injury is a no-fault injury. It doesn't matter whether the employer was liable or you were liable or the scaffolding was loose. You got injured, and as a consequence, there's intervention, compensation, and resolution. Would that be a mechanism that we would want to talk about? Tobie, do you want to maybe make some comments?
Thank you. If you're going to go a no-fault system, then you open the door to the following questions. If you're going to have a no-fault system on cerebral palsy, what happens with other neurological diagnoses or spinal diagnoses? And when you've got you've got causes which is congenital or it's infections like HIV, or if you get meningitis. And remember that the whole budget is funded by taxpayers. So the first problem that you have is you're going to open the floodgates for patients to use that system. That's why, in my mind, as the system is currently, you still need to prove liability, because once there is fault, that's when you can claim from the perpetrator. But if you're going to make it no fault liability, the problem is you're going to have a floodgate of actions. The second point I would like to address is what I had in mind is, at some stage in future, you're going to start, if you go this way, you're going to start with it at a certain stage. Now you're paying out 15 million for a CP case. The idea is that you don't want to pay the 15 million now as a once-off payment. That money or a similar amount gets channeled to what I said is this state-funded medical aid. So once you've proven the liability, that child becomes a member. And then it works like Discovery. You get your codes for whatever treatments, whether it is from nappies, whether it is from purities and foods, right through to structural changes to the house, lengthening of sinews and whatever the case might be. Now, if you quantify a CP case, the two medical disciplines that the most money is granted for is occupational therapy and speech therapy. If you've done it, you see the exercise. Now, for me, if you want to save a lot of money on that system, in every dorpie in South Africa where there is a hospital, a provincial hospital, there's 5 disciplines that you need in the downstream scheme of things. You need an OT, you need a speechy, you need a physio. It's actually 4 and a dietitian. If you've got those 4 in every single dorpie, every person with a CP child has access to the biggest part of a CP claim. And if you don't have those people there, you can get those people there on a year-by-year basis through the Zuma year, the 7th year that they do their training, stuff like that. So it's very possible to get those 4 disciplines at least in every single town. And then you're going to cut the amount of money that you pay out, which is now given as a once-off payment. The biggest lump of that is those 2 disciplines. And they are always there in the first 5-6 years. That's the most important, form of rehab that they do. So there you can cut out a lot of expenses. And then the whole idea is we've got matters that Gerard referred us to the other night. There's the Singh judgment, which is a judgment by the appellate division where they quantified a CP case from A to Z, telling you everything that is needed. There's a lot of occupational therapists who do case management, who knows inside and outside of a CP rehabilitation center and the way that you rehabilitate them. So if you go into this system where you've passed liability, so you've proven fault, and you get listed onto that type of a system. Remember, it's starting afresh. You don't have the backlog. It's not, it's just going forward. That medical aid or that state-funded medical aid will then appoint a case manager, and every single child will be evaluated. A lot of the treatment is up front, a lot of it is downstream, very far down the road. So you don't need to give out that a huge amount of expenses and monies up front. And in my scheme of things, the way I see it, that's what you want to do. You want to keep the budget in place. It works for everybody, but be careful to go a no fault, because it's going to have a roll-on effect to other diseases and other prognoses and, whatever might be made. You can't just specify to CPs. It's because it's going to be discriminatory. Okay.
Thank you. Is Lusani, are you standing in for Greg? Okay. You're Greg too. So what I thought might be interesting for you to talk on, if we're talking about this, and I'm thinking about the Esidimeni case in one instance, and I'm talking about the recent Constitutional Court representation on periodic payments and structured settlements, the question would be, does it cost the state any less if you have a cerebral palsy incident that was a non-birth trauma-related incident? 85% of the cerebral palsy, and I'm generalizing because Chris will speak about that more with greater understanding than me. But my understanding is that there's a small percentage of cerebral palsy that is created through the traumatic birth and the negligence. There's a large percentage that are created as a circumstance that is conditional, caused by many other factors. Now, the cost to the state is surely the same, regardless of whether there was fault or not. Now, how would we create a fund that would provision for that? Because all persons who are born, regardless of whether it's congenital or circumstantial or as a result of failure, need the same kind of funding.
In terms of your question, I think it might be risky for me to speak on that because a part of it is a medical issue. In terms of whether any physiology and so on is different when the two compared to when you compare the two, but certainly when you look at the symptoms and so on, there will be other factors other than what caused it that may lead to cost differences. Just by way of example, it was interesting to hear what the previous speaker said about the nature of the cost and what is the most. When I looked at an example, I work with a company that does these type of claims. The biggest cost by far was for nursing. In this particular case, it was about 56%. I think there are cases where it would be about 40%. And the disciplines that you mentioned actually in this case were about 3% or so. Speech therapy, occupational therapy, physiotherapy was about 8%, and diet was also around 3%, and then there were a few others. So by far, nursing, because what I think what you realize when you're working on those cases is that those that are preparing these cases are very, very clever in putting them together. With the nursing, it's basically 3 shifts. So the costs mount up quite, if you have 3 shifts of nurses at a certain level, then the costs per month are actually very high. It's 24 hours, 24/7 kind of care. That's why you end up with the cost being so high. Some of the actuaries that I've dealt with in this are not convinced that the cost needs to be as high as 15 million. When you look at those cases, basically what an actuary gets, he gets a lot of information. He goes into those reports and he looks for the items and put those items in a spreadsheet and calculate the present value. So in that they will say this person will need this and this at this intervals and for so long. So you go look at that and you calculate present values for that. In that sense, an actuary is pretty much a glorified calculator in this aspect. And then you send back, and then there are duplicates. There are a lot of duplicates when you're looking at those cases. And at times the instruction is, don't worry about removing the duplicates. So the actuaries don't remove the duplicates. The instructors will say they will deal with the duplicates themselves. And how they deal with it, they don't go and remove the duplicates. They just say there will be a contingency on this. And that's how they arrive at the figures of 15 or 20 million. So I think if we were to do actually proper work and look at exactly how much does it cost, even if we assume the 3 shifts, and I don't think any of these kids will actually get that level of care. 3 shifts of nurses looking after them on a day-to-day basis. I doubt that any of these would be getting. There's an item that I did not mention, transport. The number of KDs that are costed in there. Here it's 11% in that example. This KD, which in 5 years you have to get another KD, and so on and so on. Those are the type of things that one sees when one is looking at these type of claims. And obviously having a system that will provide the care, where the packages of care have been well defined, and the DG mentioned to me that they've done a lot of work in that space already. You may find that the cost per child that has to be looked after is way lower than what we are seeing at the moment. So the legal profession would have a lot to answer in terms of some of the costs that are actually being put out there and are in the claims. And unfortunately, judges have to deal with what's presented before them, and so therefore you do have case law that is supporting a lot of this judgments that are supporting a lot of these costs. In terms of from a public interest perspective, I think that one of the fundamental questions we have to ask is the whole sort of common law versus just or insurance approach and versus solidarity. What does our Constitution enjoin us to do? Does our Constitution encourage us to discriminate and say this was due to negligence, this was due to, and it's unfortunate. I think those are the values of the nation that we're building, where I do not have an answer on that one. I think it's something that we need to ask. But the experience shows that where the legal profession is involved, they do find loopholes to increase the costs. That is perhaps maybe an unfair statement to make, but I think there might be a few of you in the crowd that might agree with that. So do you want to leave that open, that door open? Would it not be cheaper then to say, as long as somebody is medically deserving, then such a fund should deal with that as well? And does that not agree more with our values as a nation than saying, let's go and fight it out in court? So I think those are the things, but I do understand the risk that it may open up to the other diseases and so on. But then the question is that what about those people? But I know that at the moment we're dealing with a CP situation. But there is a question to be asked. What about those people? Because at the end of the day, we're still talking about public resources that need to be used. I mean, the Constitution, we have to do the best that we can with the resources that we have to provide as much care as can be provided. So in that context, how far do we go in terms of discriminating? So I think having a fund, I think it's a good idea to do that. In a sense, ring fencing this type of liability. Obviously, there are questions of whether to include other people and so on. I do not have definitive, recommendations. I'm just putting that out there as a question. And then the care. I mean, I like the idea of saying run it like you would a scheme, but then also look at is it going to be more difficult or is it going to be easier for the people to claim? The way it's structured must be mindful of the people. I heard somebody commenting that in some of these cases, even after the lawyers have received the 10 million, the people still don't have the care. They still go back to the state facilities. So there are some practical aspects that we have to look at. Thank you.
Thank you, Lusani. Alex, did you want to make a comment? Yes. Please, and then there's a question from Dr. Bora. Can we have Alex respond and then you engage?
There's something anomalous in the financials around these cases, because if you have to create a standard model of care, you'd have a current prevalence rate, which is relatively stable, and you'd have an average cost for each of those patients. But what we see in the numbers is this escalating financial amount because it's based on lump sums over a period of time. And it's an artificial rendition of what's going on. So if we were looking at basically creating a standard care model that was universally available for all cerebral palsy cases, and you're funding it on a recurrent basis, in other words, you're not creating this lump sum payout, you would fund for the current prevalence of those patients, and it will be stable through time. It will probably drop over time in relation to the total population. And so when you start to look at what the annual cost would be based on, let's say, a nurse-based or even a more efficient nurse-based model with the other caregivers, and you provided that to everybody with the condition at any point in time, it would cost nothing near the health budget. And yet what we're doing is projecting a contingent liability that is now moving up to 50% of the total health budget. That doesn't make sense when you actually look at the nature of the problem itself and how you would deal with it if it were a normal medical condition, which it actually is. But because we make it a medical negligence case, we treat it differently than we would. But the issue of not allowing for a difference in care, in other words, that the care model is standard, it's not necessarily public, it's contracted, it's managed by a proper authority that looks after the people involved, it could be made available universally. And that potentially is an affordable model given what we're currently facing as a catastrophic financial situation for the provinces when dealt with in the current way.
Thank you. You want to come up here and then it's recorded and then we'll respond to it. Okay, so you're asking what is the standard quantum?
Quantum for care for a CP child, irrespective whether it's negligent or not.
Right.
What would be the standard quantum? Because what I can't understand is that when somebody gets sued, why is the quantum so much higher than if the person hasn't been sued? Is there a standard model when you calculate what care you need to receive for a CP child? Because if there is a standard quantum, then that can be used whether someone gets sued or not. You know what I mean? Because there would be a precedent set that, look, this is the amount that you will need to care for a CP child, irrespective whether it was negligence or not. So when it goes to court and someone gets sued, then you can say, but this is what is the standard of care or the quantum to care for a CP child. Why is it so exorbitant because this person is sued?
Okay. So thank you for the question. The question, just for the record, is is there a standard quantum, and what is the standard quantum? And you're going to come and answer that, and I think make reference possibly to the Singh case and the judgment attached to that. Yes, Doctor. You are the mic through me.
Please come.
Okay, thank you. No, I just wanted.
Please come.
No, I just wanted to complete say that I actually welcome the idea of educational centers and you know what I said earlier, they're trying to identify access for cerebral palsy. I think the debate is to really wait for that time on. Once you identify them, they should already be services prepared where they can access, so that you don't wait until you get education. I think that's the first one. So the idea of centers of excellence is a good one, but also just on access. If one of the debates that we have with some of the packages that we came up with is that they tend to be hospice-centric, and the proposal I had earlier of also looking at smaller dorpies and the use of some of the professionals. I mean, we produce between 8,000 and 10,000 professionals who go through community service, including allied health workers. And when they finish their ComServes, provinces are not able to absorb them. And it's a service that is already available. And these are sort of services that can be designed so that they can be immediately available and render these services. And these are sort of ideas that I think are useful, that are coming out of here, where we can look at an absorption strategy for these professionals. The two last questions is about the model of care and how the body of professional knowledge in the country based on evidence can be used by courts as expert knowledge, so that you don't just go through, a single individual experts. Like, in the UK, if you follow the Bolam case and the Bolito case, in fact, it's what the Bolam dictum. My view is that it's, couldn't we sort of study those kind of approaches and case law, both in Scotland and England. Then the last one is about the establishment, and based on what you were saying, Alex, earlier, you were looking at a much more centralized system. We attempted to come up with a National Litigation Authority. It didn't have to be National Health Litigation Authority. It didn't have to reside in the Department of Health, but it had to be, drawn from different departments. So there was a bill, but it wasn't supported. And it might perhaps be a basis of discussion and debate. We can bring it back here so that this body of knowledge debate and look at whether is an approach of centralization that involves both justice, treasury, health, and other role players.
So thank you for your commentary. And working backwards from your last comment, I think the debate following this one will discuss pretty much that issue of should there be a freestanding regulatory and participatory body that informs on that. I think in terms of access to care, Alison has a lot that I know that she's wanting to say, and Alison, I'm going to ask you to come up in just a moment. The experience that I share with Alison and you're asking about is I've run long-term residential homes for persons severely compromised and learned the lessons of what it costs to build a facility, staff it, run it, bring unskilled caregivers to skill, bring through residencies and academic institutions persons to come in to develop their skills and then write case studies and share that knowledge in peri-urban, rural and urban areas. There's a lot to that. One of the challenges that I see, and it's a tragic challenge, is the individual and their family has a health shock at birth. But by the time we finish the debate, and the legal debate and the argument about the quantum, as you've raised, it could be several years. But during those years, there's no funding for the care. So a bridging funding model, and Lusani's involved with one of those journeys now, and a settlement trust award journey with a pre-funding of the settlement trust brings that access to care that much closer. I'm going to ask you to come up in just a second, but here you had a comment to Dr. Burrett's comments on is there a standardized scale? And I know the case that I think you're going to mention. Would you like to come back? And then, Alison, if you could join after that, go through the comments that you shared with me and the visuals, and I'll change the slide deck.
To answer your question, what is the standard quantum of a CP case? There's a big distinction between RAF matters and medical negligence matters. In RAF matters, you get a statutory undertaking in respect of future medical expenses, irrespective of what the amount is. As long as you can prove that you're entitled to it and you've paid for it, you can claim it back. So in RAF matters, you don't need to prove the amount of future medical expenses. In medical negligence matters, you have to. And that's why in a medical negligence and an RAF matter, you first prove liability and then you prove quantum. Now, in liability, you use 5 or 6 experts, but when you get to quantum, you use between 20 and 25 because you've got to think on every possible type of treatment and intervention that the child might have. And that's why you use so many experts. Now, whatever those amounts are, it all now goes or relates back to the life expectancy of the child, because the longer the life expectancy, the more intervention he's going to need. Now, what happened in the Singh matter is the appellate division looked at all of this treatment, not necessarily the amounts, but if you look at nursing staff, the three, what you mentioned, the 3 types, or the 3 shifts. It's a night shift, it's a day shift, and it's a weekend shift. So it's not about the amount. So the appellate division said, yeah, if you're looking at caregivers, we will give you 3. If you're looking at occupational therapy, the first 6 months or the first year is so many sessions, and then it tapers down. So what you can do, and to give you an idea, if you look at life expectancy and you take the Singh judgment, what the appellate division said is fair and reasonable, worked on life expectancy and what the actuaries do, and they do the calculations to bring it in line with inflation and stuff, you can get a value of a claim. But that value is based on life expectancy and the types of treatment that you need. If you bring in a system like the RAF, the problem with that is you first got to pay and then you claim it back. So if you want to bring in an undertaking system with CPs, you can do that. But then you'll have to change the system so that you don't have to pay up front. And that's where I get back to that medical aid type of thing. So in short, there's not your value of your CP claim is life expectancy and the types of treatment that you can envisage the child is going to need.
Can I just make a brief comment?
Of course, I just want to capture this.
What happens if you have a CP case that is from a non-negligent problem? That means there's nobody getting sued, it's a non-negligent, it's a CP case. Are you going to use the same criteria to work out quantum for care for that baby? Because it's not fair then. Because if somebody's got CP, he's got CP. It doesn't matter whether it's coming from a non-negligent or a negligent case. You should apply the same criteria, and that's the problem that I'm having.
You're quite correct. The problem is if you've got a child that's born with congenital CP, or the cause is congenital, and you staying in Katu, you are limited to the provincial hospitals in your area for what you can get. If you need interventions outside of that they don't give to you, you need to go to a provincial hospital that does give it to you, or you need to go to a private hospital and pay for it. So I think most of the people outside there who've got CP children have no idea of the type of intervention that you can get, and they don't have the funds to pay for that. And that's why from the attorney side, and just remember something, it's not the attorneys who tell you there's a case or what it's worth. It's medical experts who tell us there's a case, and they tell us what it's worth, and the actuaries do the calculations. But if we don't inform them about it, they won't know about that. I hope that answers your question.
I'd just like to give a perspective on one of the issues that Tobie was talking about. As I understand the model that these experts are talking about, it is that in looking at the future costs of care and treatment for cerebral palsy, certain costs are standard and predictable, like the accommodation, nursing, feeding, and therapy, occupational therapy, speech therapy, physiotherapy. There's not going to be any real variability in those costs for the remainder of the child's life. So the model is to provide those costs in the center. So you don't have to, you don't give an award to the person to pay for those. The system itself provides that service. And then you don't have to quantify that because they get free access to that system, which provides accommodation, nursing, feeding, therapy. But now the variable costs are how many times is the child going to get a pressure sore that needs admission to hospital for treatment or plastic surgery? How many times is the child going to need Botox injections by a neurologist? Or how many times tendon lengthening operations by an orthopedic surgeon? Or treatment by a physician or a pediatrician for infections or kidney disease or kidney stones? Those are the unpredictable costs. And in terms of those costs, a lot of expert effort and cost is generated in 2 plastic surgeons and 2 orthopedic surgeons and 2 nephrologists, all competing about how much it's going to cost in future, and all of them are guessing. So that is, to me, where the value of the medical aid concept comes in. You can never predict those costs accurately in any one person, but one can predict the average of those costs over a spectrum of 100 or 1,000 people. And that is why a medical aid, which is properly informed, can work out what is the risk of those type of costs. And to me, it is those unpredictable, essentially specialist medical costs that are provided for in the medical aid scheme. And of course, the subscription to a medical aid scheme for cerebral palsy will be higher than for an uninjured person, member of society. But whatever is the insurance risk for those children, that will be the contribution. And if the state needs to fund the higher contributions for the medical aid, it will be cheaper than giving millions of rand for anticipated possible future treatment that might not happen, and particularly because you don't have to bother about life expectancy. You don't have to fight in court about life expectancy and have weeks and go to the appellate division and get experts from America and the United Kingdom to come and argue here about it. Because when the child passes away, the services go away. The medical aid contribution stops and the cost of care stops. So it is inherently sensible to provide the services that are predictable and stable on a state-funded free model, and the unpredictable expenses through a medical aid. Thank you.
Yes, ma'am.
I would just like to know now with NHI, National Health Insurance, imminent, how is this medical aid option going to be affected by that?
Do you want my long answer or my short answer? I don't know. Alex seems to know. And then after Alex, we'll ask Chris to come up because he's got some comments, and then we're going to finish this debate with Alison. Because Alison's going to bring the human reality of this and to just bring a closure to this afternoon's debate. Alex? And then after Alex, Chris, if you wouldn't mind.
Yeah, so just a quick response on that. I mean, the NHI is so far, I mean, it's as an institutional model, it's got a long way to go before it's actually something that's going to hit the ground running. I think that what one's talking about here as a proposal, which I think is you're actually converting what is currently being treated as a one-off, upfront calculated expense based on a fault-based system, which is highly inefficient as a way of handling such an instance from a healthcare perspective, from an insurance perspective. You're converting the entire liability into a recurrent spend. I agree fully with the idea that you insure the hospital referrals. In other words, the care, the variable care, the care that you can't predict that's going to happen, that isn't your routine care, your physios, your nursing, etc., is a standard cost which is highly predictable and which can be reduced to a per diem type expenditure. And then you're topping that up with what would be a relatively small insurance expense to fund for any referral to hospital for that person. It's not going to be very expensive, but you're converting the entire liability in South Africa for cerebral palsy cases potentially into a recurrent spend. But it means it's equivalent to a national health insurance type proposal, but for cerebral palsy. And it does make sense given the particular impact these cases are having on the fiscus to actually roll it out. And I think that the issue of saying that we divide the care that's available for people who are the victims of medical negligence from those who aren't doesn't make sense from an equity perspective. But there is definitely a transitional structure, because to roll out a care package, contract for it and set it up nationally, I would first of all say that to cost that is not hard at all, because it really requires that you have an estimate of the prevalent number of cerebral palsy cases in South Africa at any point in time. Demographically, it's dead easy to project going forward. And there will be a per capita cost for each one of those, and you've converted it into an annual budget that's manageable, and every single cerebral palsy case would have it. What you'd have to be doing is guaranteeing quality of care for everybody regardless, so that nobody has the desire to opt out of that system because they're getting rubbish service. So the issue is that provided that that's the condition for that framework, it would essentially mean that any negligence case falls to the non-medical costs only in a fault-based determination. For the rest of it, it's entirely managed in terms of a free service that's available that national government accepts the liability for. I think that converting to that makes what currently is a very difficult, unmanageable liability converted into something that the health service and the country can actually reduce to a manageable risk. The other aspect is that one does have to fix up the negligence, and that has to be repaired, and a system has to be in place for that as well. But I think that managing the liability, I think the idea of creating an insurance premium and a pre-funded service framework is the way to go, but it doesn't make sense to split out medical negligence from null, so it raises the issue of the no-fault scenario as the desirable route to go forward.
Thank you, Alex.
Yes, Alex, I absolutely agree with that. And Dr. It's hallelujah to my ears what you are saying. So the way I see it, there should be standard care that every CP child is going to need, and anticipatory care, which you should then work out somewhere else. And I think that's the kind of model we need to go for.
I think a lot of the points that I was going to raise have already been raised by Alex and others. But when we were responding to that request for input from the Law Reform Commission in 2017, our main focus was on how do we reduce the costs of insurance for obstetricians, because that was the big problem that we saw as obstetricians. And it just seemed to me that if we could avoid the costs of litigation, that would cut a lot of the costs away. And then if we could, thinking about it a little bit further, we became conscious of the consequences of the common law approach is that there are winners and losers. And it's all very well for the winners because they get a lump sum payment, and they can use that to ameliorate the costs of care of those poor children. But what about the losers? And that's when we started to think, well, maybe what we need to be looking at is a state fund that would be funded in part by the savings that would eventuate from the fact that we wouldn't be litigating as many cases. So that was the basis of the proposal. But then it does raise the question of the rights of individuals to redress where they've been damaged. What do you do about cases of negligence? And the damages awards serve two purposes. They compensate the injured for the injury, but I think they also help to modify the attitudes of the individual responsible for the injury. Now, again, if you start looking at medical injury sort of cases, it's very seldom that it's a single issue that caused the injury. I mean, I had a case just the other day where this patient arrived in the hospital. It became apparent that she was developing cerebral cephalopelvic disproportion. They checked and there was no blood in the district hospital, so they decided they'd need to move her on. They called an ambulance. At that time, she was 4 centimeters dilated. The ambulance took a long time to arrive. It eventually did, but when it did arrive, she was now fully dilated. There was no fetal distress at that point. No attempt was made. The nurses did attempt to do a vaginal delivery, but nobody attempted to do an assisted vaginal delivery because she was now fully dilated. So that was an issue as well. So she was bundled into the ambulance. The ambulance took nearly 2 hours to get to the referral hospital. When they got there, there was an ectopic pregnancy underway in the referral hospital, so there was a further delay. The net result was that there was a 7.5-hour delay between the time when the ambulance was called and the baby was delivered with severe fetal asphyxia and now cerebral palsy. So and we see so many of those sort of cases. So where do you apportion the blame? Obviously, in the state system, it goes to the MEC. In the private system, it's a lot more direct. It's usually because these other factors don't get incorporated into the judgment. They don't sort of are there to balance the equation, as it were, on the part of the defense. The obstetrician is simply, he was blamed, or and that's the end of the story. So trying to avoid that process was behind a lot of the thinking. So just some of the other thoughts that we had in terms of special damages. Obviously, Herman has referred to the variable costs with respect to ongoing medical care. A lot of medical care, as we know, we can actually calculate fairly accurately, but it's the unexpected elements of care that have to be considered as well. But the other aspect is loss of income. Now, at the moment, it depends very much on who your parents are as to how much award you get, and I think that's inherently unfair given the situation that has pertained in this country, where we've come from a situation where there are still very many disadvantaged people, and yet the award that they get for loss of income is dependent on what their parents were able to generate. So I think there should be a standard amount calculated for everybody that allows a middle-of-the-road, average, middle-income living for those individuals. So those are just some of the additional thoughts that I've got. Brad?
So we've had a very wide-ranging conversation. We're going to take one more question, and then Alison's going to close for us because, conscious of time, we need to end the debate.
Mine, Brad, is a comment. I think what we debated here is very noble. And I believe that those institutions need to be created. They'll save a lot of money. And from a legal perspective, I think if it's challenged in the Constitutional Court, given the Subramani matter as well as Grootboom matter, the constraints of the government in funding litigation as well as lump sum payments or so, I think it will be well received by the judges in the Constitutional Court. We will work with the concept of realization of resources. That's what they held out in those two fundamental cases. On the issue of, as far as future earning capacity is concerned, that Chris spoke about early on, I share the same concern as Chris. We must just remind ourselves of a herds boy, and I don't mean boy in a derogatory term, but where our father, Madiba, came from at one stage. Poor background also, and what did he achieve in his lifetime? And I'll rest my case on that.
Thank you for the comments, and they're profound, and it gives a good direction as to where we might proceed from here with endorsement. I think let's close this debate, Alison, with yourself giving some very real, tangible experience that you live every day, and maybe talk everyone through that.
So as you know, I'm an occupational therapist by profession, and I actually started doing medico-legal work because I wanted to make a difference. And then moved into case management because I found that I was completely disillusioned with attorneys, money, and found that the money was not actually reaching any of the beneficiaries. I've just summarized 3 of the cases. Actually, at the moment on my books, I have got 50 cerebral palsy children, all settled medical negligence matters. And we were talking about the cost of care. Most of them have day and night caregivers in place, and we've got OT, physio, speech and therapy in place. And despite that, the burden of care on the parents, despite having millions in a trust account, is enormous. So much so that actually in December, one of the parents, where we've already have the adapted house, we've got OT, physio in place, the child is doing phenomenally well, wheelchairs in place, caregivers in place. She's still suffering from the stress of her medical legal assessments, the stress of going through the whole litigation process, plus having a cerebral palsy child. Unfortunately, in the case of when it was settled, there was no money set aside in any specific medical legal reports for psychological damages for the mother, actually quantified as 5 psychiatric sessions. So as a result, the trustee wouldn't pay and wouldn't listen to me as a case manager when I said this mom's in trouble and she's depressed and she's not coping and we're going to have problems. And as a result, just before Christmas, the caregiver found tablets in the child's mouth and the mom is now dead. She was the only legal guardian of the child, but at least we have 20 million in the bank account. This one over here is a child that I ended up being the curator at Posodum. The case was originally, this was on the 31st of October, the first picture. That emaciated child, it was 7 years post-settlement. Trust in place, all the money in the world, no case manager, that's what you have. I was appointed as case manager 4 months later, that's that next picture. Happier child, we've got medical stuff in place, dietitian in place, therapies in place, and a much happier, healthier child with the money managed correctly. As I said, a lot of times trusts are financial people and don't know. In this particular case, the parents had also found out that should the child predecease any money left over in the trust, they would have it, and therefore refused certain treatments. I had to get a court order to actually remove the child from their care because they would have successfully murdered him. I call it murder, sorry, so that they could get the millions left over in the fund because it does go to the parents. How do I move it on to the next one? So as I said, he was deceased on Easter Monday a year ago. A very happy, very healthy child. In terms of the RAF, this little girl here, we've got her date of birth of September 2002, pedestrian vehicle accident, December 2012. RAF case settled August 2015. Experts in this audience actually saw her. She, even during the medical legal assessments, was complaining of headaches. She had a shunt. Dr. Marus actually predicted that the shunt would become blocked. Money paid out, put into a medical certificate at the RAF. Some of her future loss of earnings and jammer money, I call it, was in a banking trust. We were only referred it as case managers in the August of the 2017. By then, her shunt was severely blocked. And despite us moving very quickly into private healthcare, using her loss of earnings money, not the medical certificate, and trying to claim it back from the road accident fund, she passed away in December 2017. April 1960, motor vehicle accident, May 2013, settled March 2016. Quick referment to a case manager, but that time, that lapse between settlement and the money being in the RAF trust, deceased December 2016. I thought I'd rather end on some good news. I have several more that have passed away from pressure sores where they haven't been able to access it, and by the time we've been appointed as case managers, it's actually too late. So I thought I'd rather end on one of my better ones. Please meet Charles. He's very proud to be alive today. He was in a severe motor vehicle accident, severe brain injury, hemiplegic, severe orthopedic injuries. Was referred to me just over 18 months ago. In December 2017, the trust was no longer coping with him. He'd been living on the streets using drugs after his head injury. The trust had bought him a flat, even though he's got no capability of actually living on his own. Numerous police raids, massive credit card debt. The trust had given him a credit card. The trust had paid for 3 failed admissions into various rehabs. Since I've been involved, I had to get a law to help me get him admitted into a rehabilitation centre where he was forced to stay. He's now been clean for 1 year, 5 months. I've got him into a supported living centre. As of now, this last Friday, we've managed to get him a part-time job on the weekend. And today, he's just finished cycling 24 kilometres. He's just sent me a WhatsApp to say that he's just cycled a race doing wheelchairs to bicycles charity race. And that's him there very proudly. He's just completed 24 Ks for charity. I would like you to meet Matilda. She's one of my mom activists. This was her during the medical legal process. Stress and strain, gained weight. She was determined to lose weight once the case settled. She has an adapted house. Her child is in a stimulation centre. She works extremely hard and she motivates moms. I use her to motivate some of my other moms. Her cerebral palsy child had a very low life expectancy. He's actually outlived his life expectancy. Microcephalic, cortically blind, epileptic seizures. However, that's what she looks like today. Having lost the 80 kilograms, determined to be strong enough to be able to transfer her child, who currently weighs 42 kilograms, there he is there. With the amount of extra therapy, he's actually able to see. He's able to express his needs, although everybody said he won't need any AAC whatsoever. He is able to see the color red, and so cortical blindness isn't a true reality. It's called central visual impairment, and we can actually work with it. And he actually now will blink depending on the color of things. So if we show him a red face cloth, he knows he's about to be bathed. If we show him a red cup, he knows he's about to be fed. And if he is not hungry, he'll then shake his head so that there's no forced feeding. He can actually make choices. And that was for her halfway through. So I just wanted to say that there's ups and downs during this, and the way forward, I do believe, is with access immediately, where you can get therapy, etc., right from the beginning, because then we can make a difference and we don't lose lots of lives in between. We don't have parents with millions committing suicides. I have others being robbed because the husband gets drunk after the settlement and in the shebeen tells them that they're now millionaires. And the next minute, the caregiver is robbed when bringing the child back from school in the driveway and says, but you're a millionaire. We've heard that you guys are millionaires. So there's lots of social issues that I can't even begin to tell you with the post-settlement. That's it.
I'm handing back to you.
Brad, thank you very much.
Thank you. And thank all the...
Thank you, Brad, and thank you to Brad's panel for what was an extremely engaging and stimulating discussion. And to sit here and look at the responses from the people in the audience, Brad, you've touched on a lot of very important issues. And the one thing that Lusani said to me while we were going on, everybody here seems to be in agreement. And Lusani asked me a strange question. He said, why is everybody so level-headed? Nobody's arguing about nonsense. And I congratulate you for that, for touching on a subject that is clearly a need. And the concepts that have been spoken here are clearly a rational and appropriate and moral answer to those needs. So thank you very much to everybody involved.